Hello stenographers, welcome back to your own channel Panda Stenographer. Ready for dictation? Start. A counter affidavit has been filed on behalf of the opposite party number 3 in which it has been contended that the learned magistrate has not committed any illegality in passing the impugned order. Stop. He dismissed the complaint petition/protest petition after due examination of the witnesses under section 202 of the code since he did not find any prima facie case made out against the opposite party numbers 3 to 6. Stop. This court, in exercise of its powers, is not expected to set aside the order of dismissal passed by the learned court below under section 203 of the code since the scope of this revision petition is extremely limited. Stop. On these grounds, amongst others, it has been contended that this revision application be dismissed. Stop. A similar counter affidavit has been filed on behalf of the opposite party number 2. Stop. Para. It may be stated here that during the pendency of this revision petition, Sharda Devi, the original petitioner, died and her husband Sri Yogendra had filed a petition for his substitution in her place and for permission to conduct the case on her behalf in this court. Stop. So far as this prayer is concerned, I will deal with it at a later stage of this judgment. Stop. Para. The parties have been heard at length with respect to the scope of inquiry under section 202 of the code and also whether the learned magistrate was justified in dismissing the complaint petition on the basis of the impugned order passed by him. Stop. In this connection, I will firstly refer to the impugned order which is dated 4/5/1998. Stop. From the impugned order, it appears that the learned magistrate had taken into consideration the statement on solemn affirmation of Sharda Devi, whose protest petition was treated to be a complaint petition. Stop. He has also referred to the evidence of 5 witnesses who were examined in support of the complaint petition. Stop. Though, according to law, at this stage, he had simply to find out whether a prima facie case has been made out against the accused or not for the purpose of proceeding against them. Under law, the learned magistrate appears to have critically examined the evidence to on record and has tried to find out whether a case fit for conviction has been made out or not in the course of inquiry under section 202 of the code. Stop. Whether the case will end in conviction or acquittal is completely outside the purview of his examination of the evidence on record in course of the inquiry under section 202 of the code. Stop. This has been repeatedly held by the Honorable Supreme Court and different High Courts of India with respect to true scope of inquiry under section 202 of the code. Stop. In this connection, I will firstly refer to the case of AIR 1976 and others 1974. Stop. In this case, the Honorable Supreme Court has held that the scope of the inquiry under section 202 of the code is extremely limited only to the ascertainment of the truth or falsehood of the allegations made in the complaint petition on the materials placed by the complainant before the court for the limited purpose of finding out whether a prima facie case for issue of process has been made out and for deciding the question purely from the point of view of the complainant without at all adverting to any defense that the accused may have. Stopped. It was also held in this case that In the proceeding under section 202 of the code, the accused has got absolutely no locus standi and it is not entitled to be heard on the question whether the process should be issued against him or not. Full stop. Over. Thank you for listening my video. For better result, please practice more and more. If you like my sound, please press like button and share with your friends and subscribe your own channel Panda Stenographer. And if you have any query and you have any suggestion, you can comment below. Thank you.